Welcome to In the News. I'm David Schnurman. In the recent Second Circuit decision, U.S. versus Newman, the court placed a higher standard on what it considered insider trading. If you look at the Court of Appeals opinion, it seemed to suggest that the U.S. attorney had gone too far in his prosecution. He came to this court with a perfect record of over 80 convictions until he lost his case. Did he go too far, or was there legal precedent? With us to discuss this case in more detail and the significance of the decision is Ralph Siciliano. Ralph is a partner in Tannenbaum Halpern and the head of the firm's government and regulatory investigations practice. Ralph, thank you for being here today.
Thank you, David.
Ralph, can you take us into this case and tell us what happened here?
Sure. Essentially, this was an insider trading case against a lower level tippee, about 4 or 5 steps removed from the initial insider tip. The person was a trader at a fund, and he received information that turned out to be inside information. He was convicted, and on appeal, the Second Circuit ruled that the government failed to prove its case in establishing that the tippee who was charged had actual knowledge that the original tipper had received a personal benefit as a result of the tip.
Okay, that sounds pretty benign. From what I've read and what I've seen in the news, it seems like the Court of Appeals was pretty upset over this decision. Why?
I think the court was very concerned that the government felt it did not have to prove a very essential element of the crime. And this case follows a number of cases over the years by the SEC as well as the Department of Justice for insider trading. And there had developed a presumption that if you received inside information that initially was disclosed wrongfully, you were liable for violating the law. And it did not get into the issue or question of what did you, as the recipient, have to know about the initial tip? And that's what this case got into. As somebody who defends these cases and advises people on what is and is not inside information, the case is very helpful because typically in the financial industry, you're trying to get information to know if you should trade in a stock. And you need to know what you're receiving is something you can or cannot trade on. This case offers clarity that if you don't have actual knowledge that the information you've received was disclosed improperly and satisfied key elements, then you can use the information and not worry about being prosecuted.
So 2 questions. One, is there a common sense or common man sort of definition of what, obviously if you hear Apple's buying a company and it's not on the street yet, pretty obvious that it's inside information. How does that play in?
Very good question, because it is pretty obvious it's inside information. Someone who hears it and is following the stock will know right away it's not available to the public. So the question is, should he stop trading? This case said that's not enough to stop trading, because what the recipient has to know is not only that it's material non-public information, and not only that it may have been disclosed improperly somehow, because you probably assume that too if it's not public, but the recipient must have actual knowledge of the circumstances under which it was originally leaked. And in particular, that the leaker got some kind of personal benefit when he initially disclosed it up the line.
So what is the level of proof that the prosecution needs to define? Because that is hard to, you can say that you assume, what is the burden on the prosecution on there?
The burden is beyond a reasonable doubt, and the government has to prove actual knowledge. That's what makes this case so significant, because it's going to be very hard for the government to prove the recipient had actual knowledge, not knew or should have known, and he knew that the person received a personal benefit. And we can debate what is a personal benefit. So I think really what it means, pardon?
Let's do that. What is a personal benefit?
What is a personal benefit? The court said If you are a relative of mine and I tip information to you as a gift, that's enough of a personal benefit. I get some benefit by giving you a gift. But the court also said, if you're just good friends or social acquaintances and I give you information as a gift, it's not as clear that I'm getting a personal benefit out of that. Obviously, a personal benefit could be turning back some of the profits you got on the trade. But I think what it means is the prosecutions are going to have to prosecute people closer to the tip. The Newman case and many of the recent prosecutions involved 4, 5-level tippies down the line. I don't think we're going to see those kinds of cases anymore. We're going to see the cases where the prosecuted tippee is the direct recipient, so he obviously knows who he's getting it from and the circumstances, or maybe 1 level removed, because the government has to prove that the person had actual knowledge of the circumstances.
Now, you said a lot of the cases were going to the 4th or 5th person.
Yes.
Removed. Now, were these people, was there a reason these people were singled out, or were they in the investment community, or they were just somebody who sort of got the tip from a friend of a friend of a friend?
In terms of being singled out, they're traders, managers of money, and those are the people the government is focusing on in general. So it's not one firm. The Newman case did not involve Steve Cohen's firm, SAC Capital. It was another firm. But the government is focusing on the big firms that are trading in large quantities and trying to prevent them from trading on inside information. But at the same time, they're far removed from the initial source. The initial tippee from the initial source is somebody who's probably a bad guy, not even an industry person, just looking to sort of trade in inside information.
U.S. versus Newman was a criminal case, correct?
Yes.
So how does that differ from a non-criminal case or a civil case?
A key difference is that in a criminal case, the government has to show the intent to commit a wrong. And in a civil case brought by the SEC, this so-called intent or mens rea is not an element of the crime or the violation. However, the SEC still has to prove that a fraud occurred. And so I think we're going to have to see how these cases play out in the civil arena, because I think we're going to see more civil insider trading cases than criminal because of the higher standard in the criminal case.
And at the end of the day, you want to get some money back. So there is a easier route to go in terms of a civil case.
I think so, although the government can also get disgorgement and restitution as well. It's just that the level of knowledge that the government may have to prove in a civil case may be less.
In New York, in Europe, there's statutes that sort of cover this. It's pretty clear cut what is and what is not insider trading. It is case law mostly, correct, in the United States? And
yes.
So do you think a statute is the way to go in the future, and would that ever happen in our current government?
I think a statute would be helpful. I think you might find if there was a statute, this level of knowledge or what needs to be known might be less rigorous for the government to prove. In terms of the political environment of getting such a statute passed, I think not, but who knows?
Impossible.
And the law in this area has been around since the inception of the SEC in 1934. So I don't see this statute coming all that quickly. I do want to point out, though, that the SEC promulgated a rule defining insider trading. And they defined it in a very general way that didn't have this element of personal benefit, for example.
Okay.
So there is a rule, but that rule may not be valid if it's not properly promulgated under the statute that currently exists.
And finally, in terms of what's next, this is the Second Circuit. Most cases are heard in the Second Circuit, but certainly there's opportunity for disagreement in other courts. Is this something that you see at some point that can end up in the Supreme Court, and if so, why?
I think it can end up in the Supreme Court. I think it's likely to, because the Supreme Court, for some reason, has taken a lot of securities-related cases recently. So the court seems interested in this area. There is not too much disagreement among the circuits at the moment, which might cause the court to wait. But I would say with this case itself, if the government seeks certiorari to the Supreme Court, the court might take it.
Wow. Well, Ralph, thank you for sharing your expertise. And thank
My pleasure.
you for watching Lawline in the News.